But your lordship has seen, my lord. This is the animal husbandry. Your lordship has seen. But have your lordship knows now, my lord, that in 2019 there was an exam conducted, my lord, by the authorities, my lord. And a certain number, my lord, about 1091 my lord, candidates have succeeded in that exam. In that notification, my lord, the 10-1A candidates, my lord, for them 500 600 odd seats were kept apart, wasn't part of that recruitment process. Now, my lord, we have suggested, my lord, that let them be sit for an examination, and if they succeed in that examination, they can be retained. If they do not succeed, then they will not be retained. But this is the proposal, and those 1,091 persons who have actually sat for the examination in 2019, they should be permitted to be appointed. Then we can issue the appointment letters. If the order is to be upheld, my lord, then we go back to 2014 and will not start the process all over again. Completely, my lord. New process will start. Those persons who have succeeded in the 2019 examination, they also will have to resit the examination. This is the sum and substance of the whole thing. If the 2019 process can be saved, then these persons will get the benefit of that 1,090.
One way to do it is, wherever there has been a regular recruitment,
yes,
the court's approach should be to uphold it as far as possible.
Gotcha.
So those persons who have been selected in the right royal way as regular recruits,
yes,
their selection, let it be taken to its logical conclusion.
very good.
Those 10A appointees, while they may have to be shown the door in the present proceedings, we can extend to them the benefit of our powers under Article 142 by permitting them relaxation as to age, so that they can apply and you will be permitted to relax the requirement as to age, and they will be considered. One way of what we just.
I think that is what falls from your lordship.
What we are
the best solution. Then what we'll do is, in that event, just to understand.
Just in the loud thinking.
No, yes, just to understand, there will be a separate notification for the vacancies which are now being occupied by the 10-1A recruitees to be conducted in accordance with the same procedure which has been followed regularly.
It will be thrown open to all.
That's right.
There is nothing like anything special for anyone. All that they will
not confined to this batch.
Not confined to this batch.
All vacancies which will remain after 1,091 persons have been given their appointment. All vacancies which remain may be advertised.
No. See the vacancies how many vacancies have
Today the vacancy position will be different from what was there even in 2019.
That's true.
I believe there is 3,013 vacancies now.
3,000?
30 or 30. 3030 vacancies are there.
Now 636 where is?
Just 1 minute. Just 1 minute. Oh, number of vacant posts are. No. Have you added 573? Yeah. No, we can't go by this chart. I'm not in a position, to give your lordship the exact position. I was told that there are the total posts are 3,030. 1196 persons have been appointed in the regular force.
1196?
No. So 1196 persons are occupying their posts, Lord, and they have been recruited in the regular force.
In the regular way.
They have been recruited.
I'm sorry.
Sorry to interrupt, my lord. We are not working, my lord.
No, so this is not you.
This is
That's
not
right.
your
One
you.
more.
This is not your. This is 1196 persons who are in the department today.
As of now, working.
As of now working, yes. Then we'll have 573 other 10A1
Yeah.
persons, my lord.
573.
73.
Anyway.
10A1. So, my lord, if we leave out the 573, the total vacancies which will still be left is 1261. Yes. Now then, after that, my lord, 1141 vacancies were put to the examination, and 1091 out of them, 97 out of them have in fact been selected, but appointment letters have not been.
How many?
1097.
1097. 1097.
1097. 1097 are persons who have been recruited or selected
By 2019 notification.
on the basis of 2019.
Waiting in line.
Total
And
vacancies
this
they have
selection was in February 2021. Advertisement is on 2019.
Correct.
Selection is February 2020.
2019, 1097 are waiting. They have been regularly selected. 1097 are regularly selected.
regularly selected but not yet given an appointment to Lord because of the pendency of the
So if you add up all this, how much will it be the remaining vacancies on the sanctions?
That's the figure, my lord, which
Because your document take,
Whatever is that amount, whatever is that figure, we are not.
document take one more factor into account. In this 1097, there are 100. In this 1097, there are 118 people in service under 10A appointees.
We know that. We know that. You are.
There also will become vacancies available for the future recruitment. They are regularly applied.
Millard, we should not calculate in this fashion, Millard. We should let the department calculate and give a figure because, Millard, what is a vacancy figure, Millard, is a matter of, Millard, administrative decision. So, Millard, I don't want to do an ad hoc calculation standing before your lordship. Let us assume, Millard, that there is X number of persons who will now be X number of vacancies which would now be available in the department. This X number of vacancies, Millard, from what I have understood from your lordships, there will be a notification, there will be an advertisement for holding regular examinations for this position, and
We put it like this.
yes,
X number, we'll take that
yes,
as 573 who are appointed under 10A1. Correct?
Yes.
Now, why will be 1097 who are waiting in the wings being selected pursuant to the 2019?
Yes.
Correct?
Yes.
There should be no problem with processing their application, then immediately filling it up
correct,
in terms of what the government thinks it is.
lordship.
For the 573 plus any other remaining vacancies which the government wishes to fill, you must bring out a notification.
Yes,
In that, the 573 persons who may have become age barred,
yes,
we can consider granting them an age relaxation
yes,
and finish off this matter.
yes.
This we thought is what
Which is the bullet first.
Yeah.
No special test for anybody. The total number of balance vacancies.
Yeah.
Thrown the cat and because
here who
whether they will be in a position, Millard, to take a regular test today, Millard, I believe is in question.
Or there are 118 persons followed who have been kept in the reserve list followed out of all these 573 persons.
reserve list.
Reserve list.
What is reserve list?
There's a reserve list that has been prepared by the state followed.
When,
This examination.
when was that?
It's 118 persons.
No, when was that? When was that? 118. When was that reserve list you said?
Or out of 573 persons followed, they also participated in the examinations question. Out of them, 118 have qualified.
What is a reserve list? If it is a wait list, usually it will be for a period of 1 year. What is the reserve list under which provision?
Included in 1097.
You are falling in 573.
No.
Yes, out of 573 followed, there are 118 persons followed who are qualified in the main examination also.
In which main examination of which year?
In this 2019, 2019.
So, my lord, this is part of that 1097 persons, my lord, who have succeeded in the 2019 examination. 118 out of
Your destiny will be decided in terms of the law. Supposing you have a right under that, you proceed with it. Or if you wish to appear again in terms of the notification, you will get the benefit which you will claim along with everybody else falling in that subset.
For this 118, there should not be anything separate.
Yeah, if they have a right in terms of the route, we don't know because of weight. Who are you?
570, the 10A1.
573 people are concerned with it. They are very they have notified 2012 manner. At the time when they have studied, the curriculum of syllabus is entirely different manner.
Oh.
Now veterinary council has come. If we are competing with the other people, that will create a problem for us, manner.
The problem
One thing I want to
is
say that
entirely of your creation, and that was the High Court. We are telling you.
One thing, manner, I
Your
want to say,
appointment was in 2012 on a completely temporary basis for a period of 1
I
year.
totally agree with that.
You challenged the order in 2013, whereas next year, we know the history of how the government obliges groups falling to pressure, which they should not have. They have simply followed the law.
I'm totally agreeing with that, manner. Lordship is given, manner. This was liberty. I want to add only one thing, manner. But here, I have filed one additional document, manner. Lordship may kindly see, manner, that I have been filed on 28 March 2022, manner. Permission to file additional document. There I have stated, manner, there is a similarly, the state government has conducted those people in the earlier application 10A1 appointment in the health and family welfare department, manner. In that, they have conducted the special examination. Well, I want to create the conscience of the court to that effect that because of special test means nothing that we are going to write something, nothing, we are simply will attend the interview, nothing. So therefore, I placed an additional document before your lordship. There I have put the notification, how the GO has been done. Then notification has been given to that manner. The notification, they have given everything as a regular examiner. Only pattern is that burden will be there in the earlier syllabus they have followed from the state syllabus manner. But now what the syllabus is following is that veterinary council has come. So therefore now entire syllabus pattern everything changing. So therefore we are apprehending that we could not compete with these people. Otherwise,
Wait.
the special test means I am not saying that special test means I am not going out of the way. No matter, not back entry. Therefore, lordship may kindly seek that additional document. I will show certain things. Lordship may postmaster that is on. I filed on 28 March 2022.
See, you have engaged Mr. Dhawan. I thought Mr. Dhawan was standing, senior advocate was waiting.
Yes, I'm here.
Mr. Dhawan,
Mr.
we thought that
No, I was only going to reiterate the argument about the special test.
Oh,
There are going to be enormous difficulties.
we thought that, if you are appearing for the 10A appointment,
10A1. 10A1. We both are 10A1.
when senior counsel is there, we thought that unless you are,
I'm so sorry.
Our only
we thought that you were appearing. That's why we thought it was proper that.
friend has put it very well. Because basically it boils down to this, whether it should be an age relaxation and the general test, or whether it will be a special test for us, which will be designed to serve our understanding. Bearing in mind, of course, that there has been 10 years of experience on our part. Only bear that in mind. Because we've been there, some of them are nearing, crossing the age of 50, and therefore, the Lordship may consider whether a special test be given or not. No, I'm just saying this is a difficulty that they face.
At least I will feel, I'm sure. So you don't have to use the word perhaps. We'll all feel.
Right. But that's the point we want to make.
But you,
We only want the vacancy.
Because last time, if you lordships recall, we are the persons who were selected pursuant to a notification of 2009, not 1909. So they wrote 117 or 18 persons. 6 of them have sought to get themselves impeached as per IA number 20.
your petitions pending in the High Court.
No, they have been disposed.
What happened to that?
No, they said the learned judge did not decline to interfere expressly on the ground that the matter is pending before.
So you have to challenge that order.
So that I have to.
That is something which you'll have to follow it up on your in its own right. If you have got a right, you have to go and do that.
I have. Without that,
So we don't have to hear you.
no, not that. What I'm submitting is why I came in not at the point of time when my matter was pending. The state had filed an affidavit, and this is what the state wants to do. You're not sure. They wanted to regularize the service of 573 veterinary assistant surgeons. Lord, I got a clarification by the government of Tamil Nadu during 2012 and have been working as on date by conducting a special qualifying test. Lord, what I thought make me stand apart, these persons are.
118 is the increase will be.
They were selected after the regular selection of 2009.
That was disputed by.
No.
That was disputed.
Well, I'm willing to. I am.
And that you're first of all, are you a party in this case?
That's what my petition is one for impeachment.
So you're not yet made a party.
Not yet, Mr. Manohar. I'm responding to the
No,
You're not a party.
you're not.
You're not a party.
That's why I said I have filed IA number 20260 of 2022.
Correct.
Which was filed quite some time.
You've already launched a separate petition, and that was already disposed of.
That was even early.
Your case is based on your earlier recruitment, regular recruitment.
Of 2009.
9.
Yes.
That is projected in another petition.
Yes, which was then pending when I filed this again the petition.
So that petition is now attained finality. Some order, as judicial order is passed.
Correct.
That order is not before us.
So it's the order
You cannot, by a side wind as it were, enter collaterally in this matter and then project your case.
No, I'm not doing that.
Then don't tell me.
IA came in and
We have not yet understood what you are really here for.
That's it.
Ah.
When I filed this application, my petition was pending orders.
Correct.
But when the state moved an application before your lordships to regularize the services of 573 veterinary surgeons, they said that they will regularize all these 573 persons who were appointed in 20, but subject to taking a special test as it were.
You wanted to avoid that special test.
I wanted to avoid that. Was one of the submissions which I made. But
So if you are not going to act on that proposal at all.
saying, my lord, that I have no problem in taking the special test also if necessary.
Ah.
Lord, that is because I was appointed in 2012 pursuant to a selection of 2009. Why the submission that we may not be subject to a special test was made was because we had already undergone a test and we have proof to show that we were even and we had undergone an interview and we were even part of the select list.
What was the relief sought by you in the repetition in Madras?
To regularize this because when we were serving, another 118 persons were regularized persons to GOMS number 137. No, my lord, that though challenge, I don't think the court interfered with it. We said we should be treated on a parity. We said that we have been selected pursuant to a notification of 2009. But your lordships are also pointed out last time, be that as it may, the appointment is traced to 10A1. And therefore, the utmost that we can aspire for is to be treated on a par with the remaining persons who altogether constitute this 573 veterinary surgeons who were appointed in 2012. This is what Millard fell from the court. Of course, Millard on a tentative basis. Why Millard? What we are urging now is that no doubt Millard our repetition stands Millard disposed of. Therefore, but if this submission is being accepted, Millard, we have no problem in giving a special test if it comes to that. So that there is a quietus to the litigation. But my respectful submission is, but if your lordships are not pleased to Millard take note of this and then dispose it of this way, in which case, Millard, we have urged certain contentions in a full-fledged repetition which stands disposed of and we are in a position to challenge that same before your lordships also. If we are treated on a par as a homogeneous group of this 573, which the state says they are, then we have no issues on that. It would mean that
if we are inclined to pass the order which we proposed, namely, we are not inclined if we are not accepting the government's proposal, and instead of going back to 2014, however, as proposed by the High Court, as directed by the High Court, we say that leaving aside all those 2019 recruitments which have been done regularly in accordance with law, that will be carried to its logical conclusion, all appointments made.
Yes.
In regard to all those remaining vacancies, which includes the vacancies which would arise on your vacating, which you should vacate under 10A1.
Yes.
Those vacancies can be filled up where you also are permitted to participate, irrespective of whether you are age barred or not, by giving a relaxation, which is an order which this court we have been found, which we have found has been passed from time to time.
Yes.
Then
Not the fact that they have been occupying the post, serving.
Because of that, we will give that age relaxation. And because though you have a syllabus problem, you more than make it up by virtue of the fact that you have a lot of experience.
A lot of experience as a veterinary surgeon, in the course for about 10 years now.
And in the course of that experience, once in a while, you would have also turned over, the new books and read it also, possibly.
Practically, we may succeed if something mark is given with it. But if suppose knowledge-wise, theoretically, it is very difficult for us to succeed with it.
Why?
Well, syllabus is entirely now, even subject also different. So therefore, I have given I am not asking something differently.
Why are you advancing further? Why are you advancing further? Thought we are dealing with veterinary science, so that you can better come this side.
Can I just complete what I was about to say?
Yes.
No, would your lordships consider that the plea made by the state for regularization of the 570, I'm speaking for the 180 persons who were appointed, pursuant to a regular selection process which was done in 2009. No doubt the appointment isn't under 10A1.
First of all, who's appearing for anybody opposing his application for impleading? Order should be passed without passing it. You cannot make your submissions like this.
Yes.
Anybody opposing his application?
We have difficulty if they are sailing with 573.
We don't know whether they'll sail with you, they will sink you, we don't know.
If they are sailing with 573, we have no objection.
I said so. We are sailing with we are part of the 570.
So we can allow this application for, we don't know.
No, but the application suggests that they should be treated differently from the rest.
No. But then I'm saying this.
That's why I said I'm taking back that. I want to be treated along as part of the 573. That's all. I'm not saying.
Is it an application for intervention or impleading?
No, Mr. Giri,
yes.
By being in the part of the 573 group,
yes,
only thing you are getting is a relaxation of age. That's all.
No, I understand, my lord, but
no. I mean, if that is what you are asking,
yes,
perhaps that we have already conveyed.
I'm saying, my lord, the only point which I would try to again is to urge through your lordships. No doubt, Mr. Gupta has made it available, has made the plea for you. But to throw it open to all these vacancies, the lordships may take it as X minus Y. He said vacancies. Now be thrown out open to the public, my lord, and we are only permitted to participate in that. Put us on the back.
How can there be a limited competition? Please tell us. Article 14, 16, where does it go?
No, there was a selection done in 2009.
Nothing happened after that. You are, after all, in a group of the others ad hoc kind of an appointment. Your regular selection process did not fructify into a regular appointment.
No, that's why this plea that we made before the High Court that we regularized.
The High Court rejected that.
Yes, my lord, but that judgment is not.
And we are not confronted with an issue on examination of the judgment.
But the learned judge said that the matter is pending before the High Court, and therefore,
I don't know whether you would have been talking to sir. over another possibility. Apart from giving this age relaxation, we could also give direct the state to consider whether they can be given some weightage for the experience.
But I just
Because some cases I think it has been done by this court.
But I've just taken instructions, Lord. Either a lower cutoff or some additional marks, Lord.
Some additional mark,
Compensate, Lord, for their experience.
but subject to a maximum. Otherwise, it will be a mockery.
Selection of teachers, my lord, similar exercise has been undertaken with a cap of 20 marks.
Oh, you are appearing in that.
Yes, my lord.
This is Colin me. We did.
Yes.
I remember. There's a special set of facts here.
Therein also, my lord, they continued for a long period of time.
That is for a long period of time that the facts are different. Yeah, it's not that I am oblivious to it.
They were also ad hoc arrangement, my lord. They were also short gap.
They were
continued for more than
they were
2 years.
selected by the management committee because every year they would send a vacancy that was not being filled up. Here it is not like that. Here
Therein on specific your service basis, certain marks were prescribed
We
on
know
with a
that.
cap of 20 marks.
That's acceptable.
So, Dr. Mr. Gupta will have to tell us what can be the possible.
Grace mark was given earlier by this honorable court in the case of appointment of additional justice in the first track court.
See, the point is that each judgment we render, it has its impact on the parties, but we are also actually laying down the brick by brick foundation for a new set generation of cases in the future. Each one will say Chennai Madras matter. Let's be very careful with what we do. That is what is that they'll say this will become a precedent. Giri will say that case is there, Madras case is there. Why not?
Would your lordships like to have a look at the precedents of your lordships, my lord, which consider analogous situation? Lord, whether this is completely out of bounds for the court, my lord, to consider. Apparently, my lord, cases where
The only thing which ran in your favor is time. The fact that this case was kept pending. At every level, because otherwise, the facts are so shocking. In 2012, you are appointed under 10A, corresponding to 9A of the Kerala. We know that such cases.
yes.
Next year, they wanted to do a direct recruitment. The court stays it. The court stays it. How?
That's shocking.
Shocking. Exactly. If we are equally shocked, we thought that you wouldn't say anything more.
No, not that. But we were part of a selection earlier. And we were part of a selection earlier. There were vacancies. We were kept on the sidelines. Which is also shocking.
What did they do? Argue? You have to argue. We can see.
temporarily appointed, that could be counted for the purposes of counting, starting probation, etc. That is for the government discretion to do it.
That is strictly as per law.
Yes,
If you are entitled to it under the law, you will get it.
it is permissible.
If you are not entitled, you will not
I
get
am
it.
not asking for a mandatory order. You will actually only indicate that the government may consider. In terms of Rule 28, not Section 28.
That's why, because if they are entitled, you will get it. If you are not entitled, you will not get it.
You
Simple.
only indicate they may consider. Otherwise, they may not. Only they may consider.
All right. Then okay, that is now you are through. All of you are through. All these 2019 batch. Now, then we are.
Lord, since this 1097 Lord is clear, in the sense, my Lord, they get out of this forecast completely.
Absolutely.
Then, my Lord, Lordships may consider, and saying most humbly submitting, he will consider the state's plea of this 537, Lord, after hearing us out.
That's right. We have heard you.
Not that. And saying, my Lord said, if we, the person.
That special test, and that you should go through that route.
Either that or any other flat foods, anything.
That's where we are saying we are going to say
Yes.
that 578 plus any other additional vacancies, because we can't direct the state to fill up all vacancies. That is another restraint on us. Whatever vacancies the state actually wishes to fill, it will add it up together, bring out a consolidated notification wherein 578 10A appointees, including your clients, will be allowed to apply, number one, irrespective of the age restriction, the one time and sort of thing. Number two, for each year, subject to a maximum of a figure which we will, we'll take into consideration what Mr. Gupta will have to say to make it somewhat a little bit more than a level playing field, because it is obviously reaching an injustice to the other candidates.
Yes.
But at the same time, this is what this court has been doing.
These are.
Yes, there is something in favor of these persons for having
That is true, because you have already become the spokesperson, as it were, by coming out with this, so that you will not oppose. We know that. So what?
Lord, they have been the state's employees for 10 years. They have been the state's employees for 10 years. They have acquired experience. The state.
Let us not go that. Temporarily, you were shocked. We thought. We hope we don't get over it so fast.
No,
we continue to be.
Good points.
Yes. So some marks, for some months. So what is it that you have? What is the total amount of marks?
First for considering this matter, my lord, there are about 180 people who have sat to the 1919 examination, my lord. There are about 180 people from these temporary employees who have sat for the examination in 2019 along with us and have failed. That becomes a separate block, my lord. So you have to consider that also, because 180 people have sat along with Mr. Mariaputam's clients, my lord.
Well,
and they have failed. Now what happens to them is something which you not.
They are not before us. They are not before us.
None of them failed. They are the failed Lord. They will come within 141. That's all. They are qualified. They are qualified for the cutaway.
This consideration for the 578 is because they were appointed and they are continuing to work. If they fall in the if they are falling in the 578, they will get the benefit of whatever order you are passing. Whatever order.
Be a separate block for them, because
They cannot be a separate block as such.
Mr. Manohar,
Yes, sir.
your clients were not appointed at all.
Then they have been appointed, my lord. They have
No,
the
you said they have failed 118. They have failed.
No, but I just wanted to tell your lordship, inform your lordship, my lord, that some people have sat with us. We are qualified, my lord, proper qualification.
So then what is
But
the
there are about
distinction?
180 people who sat along with us and have failed in the regular examination.
That is it.
That's the only problem.
But they are not part of the Y578.
They are part of them. That's the problem, my lord. They are part of them.
You know, they will form in the other group, na, in the 578 group.
But they are also sat for the examination. That's all I am informing you.
What is it?
They will again appear in the examination.
Yeah, they will appear.
Because they are anyway formed this subset of 578 people.
Please, sir. I just informed it, my
So
lord.
they are continuing to work.
Please, sir. Yeah,
What you are saying is they've already got one shot at it.
please, sir.
And therefore they need not be given any special.
That's all that I want.
That's all that you want.
I will
Let my learned
for 1079 who are passing through now, who are getting out of this Milord cars. They need not be concerned about what happened to those persons who have been with the provision.
A subgroup cannot be created within the 572.
Correct. Correct.
And my learned friend Mr. Manohar's clients are not at all affected.
No, like we have understood that. Just
He was only pointing out
Yes.
a fact which is.
And as far as my clients are concerned, 118 will get appointed along with the 197 because I am among the 197.
Correct. You are not concerned.
You're not.
The important thing is that there should be certainty and the matter should progress. You know, you are detailing public service. You are for the common man. See, we are holding back the appointments.
They have,
But one suggestion, what?
they have actually been serving.
Not you. We are talking about the regular recruits who are not getting appointed.
No, I'm saying a lot of these 520s have also been serving actually.
Correct?
So, we'll have one suggestion, Milord,
Yes.
is that we
Please speak into the mic if you don't mind.
Milord, one possible way out is, Milord, to give them
What are the total marks in the examination?
Five seven.
Milord, 300 in the paper 1, medical science, 200 for general studies, and 70 for interview and record.
So for the examination, how many?
So the total is 570, and the minimum qualifying marks is 171.
Minimum qualifying in the written exam or is there an interview?
Everything together. Everything together.
No. What is the procedure? Is it a written exam followed by an interview?
Yes.
So how many marks in the written exam?
500.
500.
Yes, 500.
Voila.
2 papers, 300 plus 200. 500, and interview and record 70.
You said 500, 200 plus 200 is only 400.
No, 200 plus 300, 500.
There are 2 papers are there.
first paper is 300, second paper is 200, and Viva and record 70.
70.
70.
So 570 is the total marks.
Total.
171 is qualified.
So one suggestion is, one possibility is, Milord, okay, but that we need not. One possibility is, Milord, if certain marks are considered per year of service. They are, the question is how can we compensate them for their experience? Suppose it is, they are given 5 marks for every year that they have been in service. If your lordship feels subject to a maximum of 50 because most of them have served 10 years, approximately 2012 to 2020. But this is one way, Milord, of giving them some equity for, Milord, the years of service. So this will give them a benefit of 50.
Actually, if 50 marks, let us say somebody has worked for 10 years, and if he has 50 in his kitty, then qualifying is 171. He goes quite close to the kitty. If he scores 120, he sort of qualifies.
Well, that is a minimum qualification.
That's right, minimum qualification.
Minimum.
Thereby, he goes on to whatever.
Yes.
Eventually,
But he will not
inter-se merit.
Yeah.
It will be inter-se merit.
It will be intercepted.
Minimum qualifying marks for the reserve category is 171. And that's
Reserve, let us not trouble us at this stage. The
The
discussion.
minimum qualifying mark should not come into the equation. The lordships are trying to give them some benefit of experience. It will be added to their total marks. That's all. Also, Willard, since they have been continuing, my lord, they may continue in service if the rules provide.
To continue in service until the regular intermediate people comes in.
That's all.
The next round of litigation will be surrounding, we are just imagining the manner in which you held the examination. You will find big holes in the examination and they'll come right up to this court so that we can expect
From the result
Litigation process.
certainly, what
If every process of recruitment has so far been mitigated, then there is no hope that the next one will not be.
That's right. And all those who have performed well in the exam, they will be kept. This is a problem.
But Milord, I'll put it this way, Milord. Once it is part of an order of your lordships, Milord, at least, Milord, the principle will not be disputed anymore. If there is some, Milord, allegation that a particular candidate.
What do the rules provide for any kind of relaxation and
relaxation?
Relaxation in
Age.
Relaxation in age.
General provision is there, like Rule 39 of the KSR we have.
Yes, but it could be with jurisdiction. Rule 58. Because it is always open to the government under the residuary clause 2. Allowed to relax any specific rule by any person. But your lordships consider this. There would be nothing inequitable or unconstitutional way far away. Whatever be the reason, there is an appointment that has been served for 10 years. But for the court to say, ask the government to consider whether they could be rewarded for the number of years of service which they have. Without really not affecting any other person.
4 months per year.
Which gives the governor the power to deal with cases of any person or class of persons serving in a civil capacity under the government, or of any person who has, or any class of persons who have served as aforesaid, or any candidate or class of candidates.
Usual one.
Usual.
Rule 39 in Kerala.
Rule 39 in Kerala. This is 58 now in the Act. It used to be Rule 48.
That's right. We're not. Now, if I remember correctly, there was a direct movement in 2013, which got stayed.
No, again, Millard, the litigation, Millard, prevented.
Are there anybody? It never progressed. Nothing happened.
No selection. Nothing happened. They got a stay of notification itself. They got a stay of the notification itself, so nothing happened in that.
Oh my God.
Nothing happened.
Nothing happened.
Only 19 it went through.
Yes. Only 19 went through. Yes.
And the category 4 people are challenging it.
Yeah. That is the benefit of thinking, assembly versus 11.
49 was challenged, it was upheld.
Correct.
Lord, would your lordships kindly like to have a look at this Manipur regular post vacancies?
Eh?
This judgment reported in 91 supplementary 2 SAC 643. The book is there for you, Lordship.
What does it say?
No, my Lord, it concerns the situation where the government had declined to regularize those persons who were appointed on an ad hoc basis. But they were made to appear before a DPC. Only 23 of them got selected to the DPC, but they were not regularized. The matter reached this honorable court. This honorable court issued a direction that giving the Lord benefit of the fact that these persons had served for 5 years of
All three Uma Devi.
no, not 91.
You realize that.
643.
91
supplementary 2 SAC.
That's right. Prior to 2006.
My Lord, what I'm submitting is that this honorable report said you can give a benefit to those persons who have been serving even in an ad hoc capacity.
That's true. But not after. See, not for you because you got an order of stay. Otherwise, you would have been shown the door way back in 2013,
No,
which is the right thing to have done.
No,
All these problems wouldn't have arisen.
No, we were not. We did not have to get the stay at this point. We did not have to.
Okay. Many of you got.
I'm saying
They got the
that we were
benefit of the
continuing.
stay.
Huh?
They certainly got the benefit of the stay.
Absolutely. Within
That's not
1
what I'm
year.
saying. I'm saying that
1
we were
year.
not, our services were not sought to be terminated.
1 year. We're telling you 1 year.
Even after 1 year,
It's incredible.
we were not sought to be terminated.
No, the services would automatically have been terminated on the terms of
Saying
their
that we
money.
were continued on a day, on a regular basis, even not regular, but we were continued in the post and we continued to serve all these.
No, because the 2013 recruitment could not go through.
Absolutely.
Because of orders of court.
The orders of
Well, this judgment will only go to this extent, so that relaxations can be given.
That's all.
Right.
That's all why you cited.
Yes.
I cited it only.
we are proposing to do this 1097, like we said, it will go ahead. Remaining 578 plus whatever vacancies you want to fill up, it's for you. You bring out a notification within a particular time, because why we say this is we may permit them to continue till we may have to permit them to continue. They've got the orders of stay, I think. Of
6 weeks.
6 weeks. They want to do it.
6 weeks will not for the notification.
for the notification. Like, how long will the recruitment take? What time?
Process? 29.
6 months, 6
It
weeks.
took about 6 months. 2019 process took about after the notification 6 months. But they will have to ascertain the exact number of vacancies and all that. So therefore, 6 weeks is not an unreasonable time. So therefore, the total would become 7 months and 7.5 months or 8 months.
And what about filling up the vacancies? Those who have been
That
appointed.
we can do straight away.
Because,
That is
public-
only a question of issuing the appointment letters.
Correct.
Some time schedule may be fixed, my lord. Some time schedule may be fixed, my lord. 2 weeks or 3 weeks.
Immediately.
Very good.
3 years have already gone by. 3 years.
Yes, yes. The Lordship may fix.
So what we are then proposing is that the age relaxation will be given to all of them.
Yes. Yes.
One time age relaxation. 5 marks for every year, subject to a maximum of 10, 50. This is what you have been saying.
Yes,
We have.
that's what I said.
This should do the trick for most of you if you are really ill-equipped to be in that post. That also is also important.
And
You are still not scraping.
in fact, Lord, to be fair, Lord, 118 out of this batch did manage to sit and succeed in the examination.
That's right.
Regular examination of 29. So, Lord, it is not as if it is beyond their capacity optimal. So this is Lord, a suitable balance. Lord.
This is on the basis of the marks which you have given us.
Yes,
If it turns out to be 100, then they'll be having a complete walkover.
they'll have to walk over.
You're certain it is 570.
Yes, yes, but we are looking at
We will set
document.
it. We'll set it down. Come on, take down. And nobody else has got any submission to make.
Oh, there is one.
There is one request followed that has been made in IE number 46554 of
How many?
2022.
Pardon?
There is one IE number 46554 of 2022.
IA number 46554
of 2022.
2000.
The prayer that has been made therein is, my lord, that a reserve list has been prepared by them.
Who are you?
Or I'm an intervener in the present matter, my lord.
But who are you? You are intervening in what capacity?
I was also appointed under the temporary rules, my lord.
Tell me.
2019 selection.
Tell me.
And in 2019 selection, my lord, we have participated in the election, my lord. Our name has been shown in the reserve list, my lord.
So you should not be allowed to participate again.
So,
That's
our request is, my lord, that we should be accommodated, my lord. We have already undertaken the test and we have qualified. That is our request.
We can say that you should not be allowed to participate.
because you already.
I have been in a position to make my place, my lord, in the reserve list. That is the unfortunate part, my lord. And because all these 636
What is the meaning of reserve list?
No, what my learned friend is saying is in 2019 when the exam was held, 118 of them went through. Some people did not go through, but
have been kept in the reserve list.
In a waiting list. In a waiting list.
In a reserve list.
Waiting.
How many vacancies were notified in that?
1141.
1141 will be filled up in accordance with the rules and the seniority and
excluding 636 vacancies.
If they get, see, in terms of their position in the reserve list, if they are entitled under the rules to be appointed against those vacancies.
No, they are not. We are now sure that only 1097 out of them have been selected. The select list is also out. The waiting list is separate.
What you're saying is something different. It all depends on the rules of each state. If they have been selected, if they find a place in some kind of list, whatever we call it, wait list, reserve list, whatever, and depending upon the time within which that such a list will expire and all.
Yes.
As long as it is alive.
But here the life of the select list is till next selection.
As long as it is alive, till the vacancy is notified, they can't be appointed in excess of the vacancies. So if there are vacancies which are notified, which are available, then they may be having a right to be appointed.
It's a very costly. Otherwise, they'll be eating into the number of vacancies.
We are only asking 180 people who are being appointed.
Your vacancies are already there.
First of all, the selected person must be given appointment.
Yes.
And suppose some of them don't turn up for some reason.
Exactly.
3 years they've been waiting, some of them may have gone away.
That's non-joining vacancies.
Non-joining.
Yeah, so therefore, whatever consequences.
As per law, that's what we are telling you. But then, if that is so, then you should not be given another chance. That also we will say.
What?
No chance for you to write again.
What I am submitting, that I am standing on merit, even in the main examination of 2019.
That's right.
I am there in the wait list.
So you've already taken a short at it. Therefore, the ends there.
Not that. But that.
Relaxation.
Actually, it has to be
relaxation
because it cannot be too selective.
Correct. Not mind us, equal sufficient is this. Not that considerations. The point is this, my lord, suppose he finds a place in the waiting list, but he has not been appointed. Because my lord, these vacancies.
How are you affected?
Because he'll eat into my lord our vacancies.
Your vacancies are anyway going to be notified.
But yes, but the number will be notified, and these persons are also permitted to apply, my lord, then we will have a problem.
So you're saying they should not be permitted?
No, I'm saying, my lord, if they have a cause of action on the basis of the 2019 recruitment, my lord, they should take it up elsewhere.
They should.
They should agitate it elsewhere, not in the course of what your lordships are now considering.
Mr. Shukla.
Yes.
Sorry, Mr. Shukla.
Yes.
Please listen to my learned brother.
See, the 5 marks experience benefit, you are working, aren't you?
No, I'm not working, my lord. So I will not be falling in that category.
So then what is the point of agitating? You should not make any submission. On the basis of what the court is proposing to do, I think you should just rest your case.
And
You are not working in the 10A category.
No, you said sometime you said that
Then there is nothing, Millard,
nothing to be done there.
that he needs to intervene in this proceeding. His rights under the 2019 select list will continue as they are.
And he can apply in terms of the notification as per the usual age bar. As per the, there is no question of relaxation for it.
Yes,
Mr. Gupta, let us not prevent him his appearance. He's appearing for professional.
That's right. So we don't have to worry about you. We thought that you were working under 5.
I'm not working, my lord. We are in the reserve list, my lord. That is our grievance, my lord.
That is a matter which you work out according to the law. How many applications are there for intervention, etc.? There are a number of applications, isn't it?
Idea number 38761.
Take down.
38761 of 2022, incident bill number 4351 of 2016.
It might be, I just for the consideration of the lawyers, you might just put across a slip. There could be a mistake.
We'll do that.
Give the slip only of the intervention.
Only of the intervention.
Not
Only of
only
the-
an impeding application.
No, whatever, all intervention, impeding, whatever.
Can you give the number?
Yeah, that's it. So no, don't give it to us.
We'll give it to the court.
We are bound to make mistakes.
We'll give it
So give it on a slip of paper.
So, and we will say that all this intervention, including etc., will stand alone.
So insofar as it leads the person who have been working as 10-day-1 apologies.
That's right. But who are the others? Is there anybody else?
For example,
Mr. Gupta. The Shukla that
He is the one who is the
He is
the one who is the-
we are not falling in that category.
He is the one who is not falling.
We are not falling in that category.
Correct.
All others are falling.
Are you now pressing your application or will you lie low?
Whatever our remedies are under 2019 and even will work it out. Because our submission that 118 candidates have been selected. So those vacancies should get listed. That was our
We just, we'll allow you to, we'll say that and then say that your rights should be taken care of in accordance with the law. Correct. Plus, you be here when we dictate, you just remind us in case we miss you out. Is there anybody else? Any other applications for direction, etc., etc.? There are so many applications.
We'll give the number as it options.
11537 2016. One intervention is there also.
So, who are you?
I am also selected candidate. I have not got appointment.
2019.
2017.
17. What is this? What is There is no 2017.
I can find this up, but I don't know if somebody wants to check up, or all the parties should check up whether this list is complete or not.
Correct. But then, intervention application is at the instance of either 2019 selectees or NA appointees.
But I am provided by participants.
But he is saying 2017 there is an
No selection of 2017.
17. This is through legal aid. I got that instruction 2017.
maybe you have not been given the correct detail. May not be.
Cross check again. I will get back to them. But this is 17. I got that.
No.
Most of them are all of 2022. IA 301.
Correct. This is not an IA number. He is talking about a selection in 2017.
No, there is no selection.
No selection.
But I'll get them particulars. I'll get the correct facts from them.
The order is dictated now.
We are going to dictate. There is no question of nothing to dictate.
The number is 11537.
No, you are nobody's case that there is a 2017 selection. How you are pointing it out? Just because you are appearing as a legal aid counsel doesn't mean that you will say incorrect facts.
I got the facts. I'll get back today itself. I'll get the correct.
The order is being dictated now.
Yes. We are cheating it. So all applications for pleading and intervention will stand allowed. Correct. All the other applications will have to follow what we are going to say. So how many appeals are there?
There's 5 appeals. 7 appeals. Totally 7 appeals,
7 appeals.
including the state appeal.
So just give us the number of the appeals and who has filed which appeal, because so that we
The state appeal is 976061
9760
dash 61 of 2016.
that is Tamil Nadu.
That is blood animal husbandry department Tamil Nadu versus
That's right, that's right.
and Elumana.
Correct. Then the other appeals are all filed by the 10A appointees.
Yes, sir.
Hey, Raghu, all of them are filed by the 10A appointees.
Yes, ma'am. Yes, ma'am.
And by the state.
Yeah.
That's all. There's nobody else.
Yes, ma'am.
Yes. Batch of, in these batch of appeals, they are concerned with the fate of the appellants, bracket employees, who have been appointed under Rule 10A1 and 10A. There is 10A small one and 10A of the Tamil Nadu State and Subordinate Service Rules. No doubt, Civil Appeal 9760 of 61 and 61 bar 2016 is filed by the state. Paragraph. The appellant employees were appointed under Rule 10A in the year 2012. We need not detail the facts anterior to their appointment. Suffice it to note that under the said rule, the appointment was meant to last for a period of 1 year or till they were replaced by a regular appointee by the Tamil Nadu Public Service Commission. Correct? Correct. You are free to correct if there is anything wrong. In the next year, very next year, that is 2013, the recruitment process was set in motion by the Public Service Commission. At the instance of some of the appointees under Rule 10A1, the said recruitment process was kept in abeyance.
Was stayed by the High Court.
There was another development. There is another development, which is that the government itself came forward with a proposal to hold a special test for the appointees under 10A. There is another, what is the third development? There is one more development.
But the 2019 exam.
2019 exam.
No, apart from that, there is no other development.
Apart from 2013 selection mistake.
But the 2016 is the judgment.
That's
your judgment.
That's it. No, I remember now. And another litigation was also commenced at the instance of certain candidates who complained that the appointees under 10A1, namely the appellants before us, were selected on the basis of their being sponsored by the employment exchange. They took exception to this exclusive procedure adopted. It was their contention, which was premised on judgment of this court, that recruitment must be thrown open to all qualified and who may not be registered with the employment exchange. This found favor with a learned single judge. This was who directed selection to be made, and what is more, setting aside the appointment of the appellants who were appointed 10A1. This was in turn challenged by the 10A appointees, bracket appellants, and an order of stay was passed. In the year 2019, after setting aside the vacancies occupied by the appellants, bracket appointees under 10A1, the Public Service Commission, State Public Service Commission, advertised how many vacancies?
1141.
1141 vacancies. There were several applicants, and as per the submissions made by the learned Senior Counsel on behalf of the state, Sri Vedic, 1097 persons have been selected.
Yes.
Noticing that the 10A appointees were to be beneficiaries of a special examination contemplated by the government, a challenge was laid by certain persons to the said government order. The division bench, the 10A appointees, in fact, sought regularization. Full stop. All these cases were considered together by the division bench of the High Court. It was categorized into 4 categories.
Yes. 126 of your lordship's paper.
4 categories. Finally, the court, by the impugned order, as inter alia directed as follows. We just take it down from the
There are 15, page 126.
whatever is done. Correct?
Which page you said?
126.
126.
Of the state appeal.
Of that state athletes directed. State athletes.
976061.
As is clear from the above, the result of the impugned decision is that the claim of the 10A appointees for regularization stands rejected. Their claim for any special treatment by way of holding a special test also stands rejected. The High Court has done this on the basis of the law laid down by this court in 2006 4 SEC page 1, Uma Devi was so and so. Paragraph. When this matter was taken up on an earlier occasion, Jaydeep Gupta learned Senior Counsel appearing on behalf of the state, submitted before us the state, after considering all aspects, has been pleased to evolve a proposal which is contained in IA number
301 of 2022.
3022. But what is the proposal?
18A to 18D. Paragraph 18A to 18D.
The prayer is not paragraph 18A to 18D may be allowed.
That's right. What is that? Is that special test and all that?
Special test, yes, Lord. First, the main point is to regularize the services of 573 veterinary assistant surgeons
The proposal involves regularization of the 573 appointees under Rule 10A who are the appellants before us. That's after holding a test, is it?
After holding a special qualifying test.
After holding a special qualifying test.
Not all are appellants.
Not it.
Not all are appellants.
Not all are appellants. That's right. You are right. You must say among that 10A, all the appellants had appointees under 10A, but though not all the appointees are before us. Full stop.
Page 25, 26.
Page 25.
Page 26. 8301 of 2020.
Paragraph is at page 25.
25.
And will not clause B relates to the 1097 who have been selected under 2019 notice.
Correct. So you can just take it from there. I'll do one thing for you. The next page also, the prayers. Paragraph. The facts which have been set out in the impugned judgment and would show that the appointees under 10A1 stake their claim to an appointment which is made in the year 2012, which is a good 6 years after the pronouncement of the law by this court in Umadevi. They were fully aware of their appointment being a temporary and passing phase. The appointment was to hold good for a year at best. As was only to be expected, the recruitment process was set in motion in the very next year, bracket 2013. The said recruitment process was not carried forward at the instance of some of the appointees under Section 10A, Rule 10A. The state did not lose much time in coming to the rescue of the said appointees under Rule 10A1. And when they came forward with the proposal dated, can you just tell us when it was pending?
12th September 2014.
Very fast, 3 years. In 2014. As per the law which was laid, which has been laid down by this court in Umadevi, this court contemplated making an exception in favor of temporary appointees who were continuously without the aid of an order of the court work as on the date of the judgment were directed to be regularized. The facts of this case itself would convincingly show how regular recruitment to the posts was avoided, was prevented at the instance of persons whose appointment clearly did not entitle them to continue beyond a period of 1 year. The High Court has, in the interim judgment, noticed all the facts and applied the law as it ought to have. And we do not think that any case is as such made out for interfering with the order of the High Court, except to the extent that we shall indicate. Full stop. Having said all we have about facts which are indisputable, it is equally a fact which we cannot overlook, that this case, having been filed in the year 2016, we are dealing with an appointment, or we are dealing with appointments, though meant to last a year, has continued for nearly a decade. On the one hand, the state itself has noticed from the proposal it has put forth, come forward to give the benefit of regularization after a special test is held. Having considered submissions which have been made before us, we have the view that while we should not accept the proposal of the state as put forth before us, we must also, in the interest of justice, adequately address the aspect relating to the 10A appointees. In whose favor the greatest aspect is the passage of time and its impact on their lives. This is apart from the fact we cannot totally ignore the dimension that they have over the years gathered considerable experience with the discharge of their duties. Full stop. Bearing in mind all aspects, we are inclined to dispose of the appeals the following manner. Paragraph. It is undisputed that a recruitment process was set in motion for making regular appointments in the year 2019. It is further undenied that 1097 persons have qualified, and what is more, they are awaiting appointment, and their appointment has not been made primarily based on the pendency of the litigation before this court. We see no reason why their appointments should be kept in abeyance any more further. Sri Jaideep Gupta, in fact, submits that there is no obstacle in law in effecting their appointments. Therefore, we direct that the 1097 selectees pursuant to the notification issued in the year 2019 shall be appointed in accordance with law within a period of 2 weeks from today. 2. As far as the 578 573 appointees under Rule 10A bracket, many of whom are appellants before this court. We have the view that they should, while not be permitted, be regularized in the manner proposed by the state, be granted relief in the following manner. The appellant state, appellant in so and so, appeal number
976061
will proceed to notify vacancies, including the vacancies held by the appellant before us, as also all the 10 appointees within a period of 6 weeks from today. 2. The appointees, the appellants before us, so we are extending the benefit even to persons like Giri's clients who have not come before us.
Yes. Because your lordship has said all other.
Because we thought that all of them have come here. That's why we thought. Then
Not
how,
all come, not
but then how were you continuing? You were continuing on the basis of some other order.
No, because they are part of 570.
they are part of 570.
Or because they are continuing as it is.
They continue.
Since 2012.
They wanted a special benefit.
That's
that
right,
is
because the
not-
High Court's order will remain. That's right. So 578, 573. What did you write?
The vacancies held by the appellant before us as also of the of 6 weeks from today. And the
Second, the appointees under Rule 10A will be granted the benefit of relaxation, age relaxation, minimum age relaxation, upper age. The upper age relaxation, so that they are entitled to apply and be considered with anybody else who is eligible to apply and applies. 3. In the facts of the having regard the appellants, the appointees under 10A, including the appellants before us, will be afforded weightage, marks of weightage of experience in the selection process at the rate of full stop. The weightage will consist of marks at the rate of 5 marks for every year. This is subject to a maximum of 50 marks. This we are ordering on the basis of the submission by Sri Jaideep Gupta that the scheme of examination, the recruitment process concerned, the selection is made on the basis of a written examination which consists of a total of 500 marks split up into 2 papers, of which one paper the maximum marks is 200, and for the second paper, the maximum mark is 300. The recruitment procedure, according to Sri Devi Gupta, also entails a Viva OC for which the maximum marks is 70. Therefore, we proceed on the basis that the total marks on the basis of which selection is to be made is 570.
But the first paper is 300, second paper is 200.
Second paper is 300. What are the papers?
First paper is 300.
First paper is 300, second paper. Full stop. VK Shukla. Just one thing. See, VK Shukla, you could see that there are senior counsel appearing in.
My IA number is 46554.
Submitted that his clients had applied pursuant to the notification issued in the year 2019, and they find that place in a reserve list. They are not claiming to be appointees under 10A1. As far as the said persons are concerned, it is for them to work out their remedies in accordance with the law, with reference to their being selected in a finding place in a reserve list. We leave it open.
Or in fact, the petition in question has been filed and on 1st April it has been dismissed because the matter has been pending before this court. Yeah. So, your Lordship may kindly make a mention. We can pursue out that remedy also.
What remedy?
Or on 1st April 2022, the petition filed by the petitioner has been dismissed because the issue was being considered by this court, my lord. So, all the issues have been.
You have filed the petition also.
The petition had been filed, my lord.
And then what happened to that?
That has been dismissed on 1st April, my lord, with the observation that the matter is pending and all issues are being decided by the apex court, my lord. So we have to work out the remedy.
That's what we said. It is submitted that you say that, otherwise you will be guilty of suppression, as we say. It is in fact submitted by Sri VK Shukla that a petition filed at their instance has been dismissed on the score that the matter is pending consideration before this court. We leave it open for the petitioners, the persons clients represented by Sri VK Shukla, to work out his remedies in accordance with law.
Okay. Continue to your service till the selection process.
IA, please put to the IA number. Give the IA number correctly.
It's IA number 46554. 46554 202.
Stop. Paragraph. In view of the direction which we have passed, the impugned judgment will stand modified accordingly. In other words, there is no need to issue the notification on the basis Mr. Gupta, you are saying 2014 something.
Yes, I tell you that.
It's sufficient that we say it is modified.
Yes, it's enough to say it's modified as a matter.
It stand modified as in the above terms. The appellants bracket the appointees under 10A1 shall be permitted to continue. Is it necessary to say that?
Please, otherwise the selection process.
Because otherwise the vacancy is not created. If you do not terminate, then the vacancy is not created unless your lordship says.
Within what time will you complete the recruitment process? We don't want you to be hand in glove with her.
No, so your lordship may give a time frame.
6 weeks we have sent for the notification.
For the notification, 6 months for the completion of the process.
We must do that.
What?
You must say recruitment process should be concluded as early as possible at any rate within a period of 6 months from today.
6 months after
8 months.
1 month before some.
Tamil Nadu Public Service Commission.
Correct.
Because that direction of 6 months completion, Lord, should be Lord given to the Public Service
You
Commission.
got a party here?
Yes, yes, they are parties.
Who's you are appearing for?
I don't know if I'm appearing, but they are a party.
They're a party.
So your lordship can in the order provide
That's
that
right.
the Public
The
Service
public Tamil Nadu Public Service Commission. So the notification also has to be issued by the within 6 weeks.
Yes, yes.
Notification by the government.
Is there anybody appearing for the commission? Ah, you're here. So 6 weeks you have understood. 6 weeks. Tamil Nadu Public Service Commission responded. You find that out in total. Will be concluded. I mean, concluded within on or before 30th November 2022. That is more than sufficient time. You require so much time actually. No, what you're asking is, do you require so much time? You have to hold exams and maybe you require.
Your lordship has said at the earliest, not later than.
Not later than that.
They can do it earlier, but
All right, all right.
Services are protected.
Very good. The appellants bracket the appointees under 10A rule 10A.
Saying appellants and 10A1.
We know that.
Bracket within bracket is only appellants will come.
We know that. That's why we kept quiet. We are saying what we will say.
That's not.
Let us start with the appellants. We will consider you as that. You're not.
No, that's he said from the beginning. I haven't said that.
You're not here. You have just come. And what about those persons who we are not even representing? Are you representing order then?
Lord, in substance, there is no difference between those persons who have come up in a other 10A1.
You are passing an order in favor of somebody who is not challenged it.
Some of them have come. Some of them.
How many are before this? Tell us.
363.
Huh?
363.
You have counted it.
All petitions together, my lord. 5 petitions, my lord, we file.
All right.
All together it will come 363.
I have 5 included application of 5%. Then you want to find.
Okay. Anybody else is there? Tell me.
I am representing 77 villages.
Eh?
77. I am representing 77.
That's different, Lord. That's the 118 persons who have been selected in
These are also 10
2019.
appointees.
Maybe what we
All will be protected.
I stand protected.
all
by a-
10A1
Always
appointees will be protected.
appoints.
Options always.
They are all working even now.
yes,
Yes.
okay.
63.
One thing before I forget. In the notification inviting applications to be published. The Public Service Commission shall specifically indicate that the 10A appointees, bracket 573 in number, will be granted the benefit of relaxation from age and also the addition of weightage of marks towards your experience in terms of the order passed by this court. Otherwise, again, it will give rise to what you are doing. Then finally, we say first you say that the appellants or any appointees shall be permitted to continue you'll
the selection process completed.
I apologize. Actually, Lordship, the state is to give me vacancies and the procedure is going to take time.
You speak in the way, I can't hear you.
The state is going to give me vacancies and the procedure is little time. This week instruction to my senior that I need little more time for the notification.
So make it 31st December.
If you Lordship may.
Make it 2 years, 3 years. You have to do it fast.
Lordship, we grant some more time on this.
Wait. How many vacancies are there to be pursued? How many vacancies are there? So, you will follow, what she says is right. You know the procedure is. The department will have to make available the vacancies. You don't know how you have been reporting vacancies or not. So you have to report it within a period of, say, 2 weeks maximum. Then you can bring out the notification within 1 month, which is how we fix it 6 weeks. Just say that. The concerned, the appellant department, the appellant is state appellant, that is 976061, or the concerned department working under the respondent, appellant.
The appellant is the department.
Appellant itself, okay. The appellant will report the vacancies, including the 578 vacancies, 570 vacancies of 573 vacancies occupied, held by the appointees under Rule 10A, and any other vacancies available as per law within a period of 2 weeks to the Tamil Nadu Public Service Commission. And then you say you will bring it out within 6 weeks. So you don't have to worry about that. And then we'll make it up to 31st December. Correct? Instead of 30th November, 31st December. So then shall be allowed to continue. Lastly, appellant stroke tenure appointees shall be allowed to continue. Till what time Jaideep Gupta will be allowed to continue?
About one thing, that we would know the exact vacancy position after appointment is given to the 1097 persons. So 573 we know, but if anything other than 573 is to be included in this batch, that decision can only be taken after the 1097 have joined.
So what's your suggestion?
The reporting will take 4 weeks. 2 weeks they will join. The Lordship has provided. Within 4 weeks, we will report the vacancies and whatever time.
So we'll make it 1 month. And then 1 month for them to notify. 4 weeks for the appellant to report the entire vacancies, including the 573 vacancies to the Public Service Commission. And the notification, then you will bring it up, you get 2 months. 1 month after they report, you go ahead and tell. So they will be allowed to continue. They will be allowed to continue to what time? Some of them may get selected naturally.
Yes.
So those who are getting selected, they don't have a problem. But
If the process of selection is complete.
yeah, till the process of selection is complete. It shall be allowed to continue till the process of selection is complete. Though all the 10A appointees have not filed appeal, the facts of we do think that there always should the benefit of continuance of the appointees under Rule 10A should be extended to all persons appointed and who fall under the group of 573 appointees under 10A1. Therefore, though, the benefit of continuance till the selection is complete will extend to even those who have not filed appeals.
But are you not in the list of 573 persons?
But who are part of the 573 persons?
Yes, that's it.
Appointed under Rule 10.
Because my application says that this 573 is working.
That's right, you're saying. That's all. So that let's into the matter.
So great.
Appeals are, you can say, disposed of is about.
I have made a request regarding the benefits which are available under sector.
As per law, you
Actually, I make an observation that government may consider that.
will get it. As per law, you will get it. Why should we say that? Whatever, that's a separate cause of action for a lawyer in Tamil Nadu.
Yes, so great.
Yes.
I get that statement that 2017, I got the that is 2019.
So we have allowed your application.
Yes, yes.
Whatever is allowed you. Yes.